All right, President Cyril Ramaphosa and his predecessor, Jacob Zuma, went head-to-head at the High Court in Johannesburg today. Ramaphosa is fighting to block Zuma from privately prosecuting him. Zuma claims Ramaphosa is an accessory after the fact in alleged criminality by prosecutor Billy Downer and journalist Karen Morn. Judgment in that case, as we've heard not so long ago, has been reserved, and we are likely to hear something on Monday, 9:30. Joining us is Nthabiseng Dubazana from Dubazana Attorneys, who will give us more on this. So, I mean, essentially, Nthabiseng, thanks indeed for talking to us. Today was really about deciding whether or not this is an urgent matter. From what you heard in court, what do you feel about everything that was said there today?
Well, from what we could hear, the judges probing from the different legal counsel that was present before the court, particularly Ntate Ramaphosa's legal counsel, they wanted to understand why do they think that this matter is of such urgency that it should be heard prior to the president having to appear in front of a criminal court and raise the same issues that would have been raised here today in that same court. And the main reasons that they kept reiterating is that because he's holding a public office, because he has, all these other duties that are resting upon him in order for him to execute his functions in the office that he holds. And obviously the court did not give an indication in which way they're going to go, whether or not they agree with the arguments that are led by counsel in that respect. And then in contradiction to what counsel for Ntate Ramaphosa was saying, counsel for Ntate Zuma was saying that it cannot be just because the accused person holds an office that is a public office, that they should not be subjected to the uncomfortableness of having to appear in court and answering to the allegations against them. In fact, if I remember correctly, Ntate Mpofu said, we are not saying the office of the President of the Republic of South Africa is an accused person. We are saying that Cyril Ramaphosa is the one who is the accused person in this matter.
Yeah, and it's quite interesting because he actually verbatim quotes the name on the document, which doesn't have the word president in front of it. I see Dali Mpofu also saying that in all of this, President Cyril Ramaphosa should have acted immediately. There was a delay, and that in itself speaks to whether or not this should be considered urgent.
100%. That's an argument that I would have also set forth, because urgency means that once you receive the documentation, which is the summons that was sent to the office of Ntate Ramaphosa, that you're now being summoned to appear on the 19th of January on criminal charges based on 1, 2, 3, 4. The moment you receive that, you approach your legal team and say, guys, I don't want to go through this. Can we do something about it? Give it 2-3 days, perhaps at most, sometimes a week. And then you act upon it to show that it was urgent enough for you to act in order to prevent what was going to come. But with the delay that has happened, now the court really is sitting there and wondering, is there a real urgency in this matter, or is it a situation whereby the highest office in the country, the person sitting in it rather, is making the use of that seat and choosing not to come and appear in front of a criminal court? Because one of the arguments that have been set forth is that let's not mix the jurisdictions of the courts in terms of what they can do. Let's not ask civil courts to now answer what should be done in criminal courts and vice versa. So we'll see how the court dabbles with that situation.
Yeah, also interesting on the part of Dali Mpofu, he tries to argue that Ramaphosa failed to deal with the Zuma complaint against Downer because of what he says, quote unquote, bad blood. And again, I mean, this doesn't appear to be amounting to some sort of criminal offense, does it?
No, it doesn't really. I wish I had access to the docket to see exactly what it is that happened that made them choose to open a case of accessory after the fact. Let's make an example. When it comes to the charge of murder, you see me, I've just killed somebody and they're there, and then you come down and you help me hide the body somewhere. You are now an accessory after the fact. So now you can also be charged with the same crime of murder. So now if we knew exactly what it was that he did or didn't do, because an omission can also be fall under the ambit of a criminal offense. What he did or did not do that then make him also be made accused number 3 in the same proceedings as Billy Downer and Karen Moore, that I think would make it a little bit more clearer for us to see if there's even a case for the president to answer to in these proceedings.
What's the departure point here that would lead to a decision come 9:30 on Monday morning for you?
So the first thing that they have to start with as a court is, did they satisfy the element of urgency? If that is a correct tick, then everything else that came afterwards can then be dealt with. But if the first leg of the test, which is that of urgency, is a fail, everything else is a fail. So that is the first thing that we need to, we will be hearing or expecting to hear come Monday 9:30. Was this matter indeed urgent per Section 6 of the Act? And if indeed so, then it means that the interdict will be granted based on Part A, that is the request, and then Part B will be dealt with obviously at a later stage. But if it comes back and saying that there was no urgency, then Part A, Part B, all of the interdict application falls away in its entirety.
All right, so we'll wait for Monday morning. Thanks very much indeed, Nthabiseng Dubazana from Dubazana Attorneys there, talking to us or giving us some analysis on what happened at the Johannesburg High Court.